an opening prayer.
Jesus' name.
Amen.
Amen.
We thank you for a time like this. We thank you for this gathering. We thank you for SP. We thank you for every member of Section 103 and the council. Everyone that is presented here, we give you thanks for our families. We thank you for this deliberation. Father, we give you glory because all things we're going to hear here will move ourselves and SP forward. We thank you for even the one that is delivering. We thank you because he will be impacted, even in his knowledge. In Jesus' name, amen.
Amen.
Amen. Simeon. So next we have on our agenda is the safety brief stroke safety moment. Please mute your mic when you are not speaking. And anytime you want to make a comment or want to speak during the question and answer section, it's advisable that you raise your hand so that we can call on your attention to speak. And when you want to post comments, use C as comments, as a prefix before your comments, and then a Q as a prefix before your questions. Ensure you can still hear the firm fire alarm with your headset. Even though we're at home, so we should be at alert and be aware of our environment and always stay safe. This COVID-19 era, so anything we are doing must be very conscious. Wash your hands regularly. Stay at home. If you are feeling sick, cover your mouth when you are sneezing and avoid touching your face when you've not washed your hands. Thank you very much as we progress. The next we have is welcome address. Actually, are you taking it? I should take it.
Okay, I'll just go ahead. Yeah. Thank you everyone for attending this monthly technical meeting for May. In fact, we've had one yesterday, which is a technical event also. But this is actually the main one we've marked for the month of May. So we have this topic on owning an intellectual property, if it's a rocket science or not. So we have our distinguished lecturer, Dr. James Arukwe, that have gone around the world, as you can imagine. We have other members from around the world that will be joining us also. We're really excited with this and really appreciative of this gesture for him to deliver this lecture to us. If you are aware and if you follow Dr. Arukwe very well on LinkedIn, you will see that he has so many patents. So it's good that there's love in sharing. So he just want to share with us some of his secrets of getting all these patents. Like every 6 months, I think he's getting one of them. So thank you so much, Dr. James, for this gesture. Also to our moderator that will be taking us through this technical section, Dr. Tobinson Briggs. You've been here like even before the time we asked you to be here. So thank you so much. You are so punctual person. So next time I'll watch out for you. I'll beat you to the records, that's for sure. But this time you all beat us up. Thank you so much for coming so early. Just before we declare the event open, I would like to appreciate very quickly our next Vice Council Chair, Mr. Felix Obike. In fact, I think we cannot finish saying it here. It's one of those that put us through the ropes to this time, knowing how to handle many of these things we do in SPE. Thank you so much for all your service for SPE. We also have Frank Egede, who is the Warri section chair. So I'm very sure along the line, we'll be recognizing most of the dignitaries we'll be having. Also, other members and all over the world that will be joining. So we hope they get here on time so that they don't miss out. But in any case, we'll have it on YouTube. But you know, the one that is live is much more nice and better, in fact, than the one you now go later to watch on YouTube. So the programs chair, I've mentioned it the other time that please, if you have questions or comments, if it's question, put a Q just before your question, and if it's a comment or information, put a C. It helps our members, you know, that will be interacting with you in the chat box to quickly pick up the ones that are questioned to the teams that will be passing it across to presenters and the moderators. So thank you. That is very key for us. So I'll just start putting it, but ensure you put the prefix of Q or C. So I would now like to declare the event open, of course, in recognizing the directors of Section 103, members of Section 103, the students and our young professionals. So I think we can just start. Thank you very much and welcome.
Thank you very much, SC, for that welcome address. Next, we'll have is introduction of the moderator. I'm going to handle that. Simeon, can you quickly project citation of the moderator? Citation of Dr. Tobinson Briggs. Dr. T.A. Briggs obtained his doctorate degree in mechanical engineering from the University of Nigeria and a postgraduate certificate in advanced studies in academic practice from the University of Newcastle, UK. Dr. Tobinson Briggs has published some research papers in learned reputable journals, both here and abroad. He has a high sense of research, curiosity with a great intellectual drive. He has been a head of department and a lecturer of mechatronics engineering, an acting director of Intellectual Property Technology Transfer Office of the University of Port Harcourt. He is currently the acting director of the Offshore Technology Institute, University of Port Harcourt, and a member of the University of Port Harcourt team for Transforming Energy Access Learning Partnership. Thank you very much, Briggs, to take us through the moderation of this session.
Thank you, sir.
So, Briggs, from this moment, I hand over part of the section of this program to you. So the next is that you are going to read the citation of the speaker and then take us through to the question and answer section.
All right, thank you, Joe. The speaker we have here is James Arukoya, is a project lead from Saudi Aramco. I just want to give the citation already displayed on our slide. I hope everybody can cite it from wherever we have in our various rooms or offices. Dr. James Arukoya, project manager of Saudi Aramco's ambitious development in the world's 5th largest offshore field, will advocate balancing economic ambitions with environmental responsibility using Manifa case study. James received his first degree, BA in petroleum engineering, and has been with Chevron NNPC scholar, beneficiary from University of Benin. He has an MBA executive from University of Lagos and an MSc in petroleum engineering and an Alberta government scholars in the University of Calgary. Although he was sponsored by the government for that, he's a big beneficiary of the Nigerian government. So he's giving back to us now. James received a doctorate degree of management in organizational leadership. And that scholar that led him to that from University of Finance, USA, and was a valerians for 2015 commencement ceremony in Arizona, USA. James has published several papers on various subjects, fields, 6 intellectual patents on smart well ESPs, and adaptive disposal well system and simulation treatment. It's my pleasure to present a great scholar in the industry, an industrial scholar for this month of May workshop. Ladies and gentlemen, here I present Dr. James Arukoye for his presentation. Dr. James, sir.
Thank you for the generous introduction. So my company is Saudi Aramco. It's a world leader in oil and gas, and I stand here today proud to represent the company. Well, I just wanted to let you know that I really appreciate all the SP officials in Port Harcourt, the directors of SP everywhere that continue to make great efforts to hold these lectures despite a very challenging year. So I acknowledge all the senior colleagues here, all the faculty, students that are also here, are leaders of the future. So 2 years ago, precisely in 2019, I decided to explore the world of intellectual property. So I filed my first patent. Before then, I used to have, write papers, and I took joy in doing that. But I discovered that I represent only 3% of experts, 3% of the workforce or the employee human resource population in the company. And I really need to think of adding value to the company. And patents was one way I could really show my appreciation for a company that has really taken good care of us and our families. And so I filed my first patent in 2019. And since then, I filed several other more, 6 already, but so many are in the pipeline as disclosure, invention disclosures. So this evening, I'm hoping I can show you how you can reinforce your preeminence in your industry, help your organization to do so through developing intellectual properties. I'm going to lead you through the journey in Saudi Aramco, show you some examples of how we have led in technology development and innovation. And almost always, intellectual properties help to maintain capital discipline for the company, financial prudence, and also to manage risk. Intellectual properties help to grow sustainably, promote citizenship, and add value. And the interesting part of it is that I believe that owning one is not rocket science. But again, that depends on how you see it. So I'm going to share my screen, and then we'll get right to the presentation. That's the topic. Owning an intellectual property, isn't rocket science, or is it? So I must confess that the road to discussing this sensitive topic to outside parties was not easy. You can see from this slide that I had to request permission to engage in this talk from the appropriate quarters, and that's the right thing to do because intellectual property is critical to fostering innovation, and companies do protect their intellectual property rights. Intellectual property rights and registrations allow companies to protect their research and development activities and core business while creating a stronger negotiating posture for cross-licensing and counterclaims. Intellectual property is counted as an asset when determining the value of a company, and can even be used as collateral for a loan. So, for example, in acquisition negotiations, you can put the value of the offer on the table, but you can also say, I have non-tangible assets in intellectual properties, and therefore, if 100 million is the asking price for buying up the company, you can put 50 million down and say, well, the other 50 million is in my non-tangible assets, which are intellectual properties. So that's how important it is when you think about it in that way. So it's a clear technological passageway for future market share. And that's why individuals and companies aim to reap full benefits of their innovations and focus on intellectual property development. And the good part of it is that, well, I did get the blessing of the company to do this, and I'm hoping I will discuss very frankly within the boundaries of the privileges, and then answer your questions as we go. Okay, so let's see the outline for the talk. I'll give an overview of intellectual property, include patents, trademarks, trade secrets, and copyrights. And I'll take a deep dive to review patents and the typical patenting process from invention disclosure through filing to grant, using my company, Saudi Aramco, as a case. And I'll show some patent statistics for the company, which you know is very dynamic. Then I will answer some of your questions, all of them. So as compared to other types of intellectual property, patents are among the most difficult, costly, and valuable to obtain. Okay. So what is a patent? Patent is a legal right, okay, granted by the government to an inventor to exclude others, and that is key. All right. Patents don't give an inventor the right to do anything, but rather it gives the right to stop, to deter, to block others from doing something, or from making, using, offering for sale, or selling the invention. And patents are territorial, okay, in a particular territory for a limited time. Typically, it's about 20 years from filing. And this patent right is granted in exchange for public disclosure, which means I put an enabling disclosure, that is, I teach the world how to do something in the patent, and in return, the government gives me the right to exclude anyone making use or selling what I have taught them for a particular time. Okay, so trademarks. A classic one is Coca-Cola logo. And trademark protect words, names, symbols, sounds, or even colors and brands. And examples are the NBC or the BBC, okay, or NTA chimes. You know, those could be sound trademarks. Colors like the orange or T-Mobile pink can be trademarks. All right, and so the key is that these words, names, symbols, colors distinguish goods and services from those manufactured or sold by others. So if I have a trademark, it must point to me as a source. And if that mark does not point to a single source, it's not going to be a valid trademark. And one thing I want to point out is that trademarks do not expire, unlike patents that have a lifespan of typically like 20 years. Trademarks do not expire. You can continue using it in commerce and it can last forever. But if you stop using it in commerce, then people can show that you have stopped using it in commerce. They can petition to revoke your trademark. Okay. Trademarks cannot be generic or descriptive. It should be suggestive or arbitrary. Something like Xerox, all right? Xerox is not a word. It is made up. Okay? And that's a good trademark if you could get it. But you can lose even the best of trademarks like Xerox, because when people talk about making a Xerox copy, right, as opposed to making a photocopy, that genericized the word Xerox, and the trademark was gone, because now if you use Xerox to mean photocopy, it did not point to source anymore. Okay, and the trademark will be lost. Same thing with Google. People say, "Can I Google it?" So whenever people start to use the noun as a verb, then that trademark is at a risk. And the good thing is that we can have our trademarks. Like I do have my trademark, and I'm going to show you my trademark. So something for you to consider is a way to. So this is just my own little trademark as someone who's put in 12 years in the company. I talked to the legal team, said, well, it's not a problem. So I had my trademark, and to show the kind of, to distinguish myself, my services, even as a valuable employee within the company. All right, so copyrights, trade secrets. So trade secrets, what are trade secrets? So trade secrets is a confidential or proprietary form of information. So that includes like a formula, a pattern, compilation, program, device, method, technique, process, or anything actually. So that's the key is that it derives independent economic value from not being known to the public. All right, so if you have something that is secret, and because no one else knows it, you can obtain economic value from it, that will classify as a trade secret, provided, of course, that you take reasonable measures to keep it as a trade secret, to protect it. So if you don't, you will lose it. Again, KFC secret, the blend of 11 herbs and spices, or McDonald's Big Mac, the special sauce, or the algorithm that is in Google, these are trade secrets, okay? And they closely guard it. I was in Coca-Cola facility, and I drank more brands of Coca-Cola than I even knew of, but then the Coca-Cola recipe is also a trade secret. So because Coca-Cola derives economic value from it, they've closely guarded it for many years, and up to 85% of the value of Coca-Cola actually resides in the trade secret, and they do a very good job in keeping it secret. So that's what trade secrets are. What are copyrights? Everyone knows these ones, especially with social media interactions. So these exclusively protect works of authorship, okay, and creative works such as writings, music, or artworks, okay, even photographs, materials from the internet, so long as they are expressed in a tangible medium. Okay, and by international law, once the creative works are in a tangible medium, it's covered by copyright. So the person doesn't need to register it. If you use it after it has been expressed in a tangible medium, then you are in violation of copyright. Okay, and when I was doing my doctoral studies, my supervisor gave me back my work with hundreds and hundreds of comments, because every picture I took from somewhere, every graph, every animation, anything I took that was not my original work, she demanded that I take the pain to contact the original author. So I had to write more than 100 letters, 100 emails. I had to trace authors, even when they have died. I have to go to the publisher, write the publisher, and get the publisher to give me the right to use whatever work I needed to use. So that's how serious the US office takes the violation of copyright. So because Copyrights can last past the death of the author, typically for 50 years. So if you think because the author has died, you can use his work, you could be liable. Okay. Sometimes, for us who are working in the oil companies, we need to be very careful because if I go out of negligence and go and be in violation of copyright and make my company liable to millions, the company is not going to be happy at all. So you have to do a lot of due diligence, okay, to make sure that you seek permission from the copyright owner to print, publish, perform, film, or record literary, artistic, or musical material. So the original author does not issue a writ or breach of copyright. So you know what the copyright symbol is, whether or not you see it, like a letter C in a circle, whether it's not put there, so long as that work has been expressed in a tangible medium, you have to assume that the copyright law applies. Okay, and they also design patents and protection of graphical user interface, but we'll just go on. Okay, so I already said that patents are among the most difficult, the most costly, and the most valuable to obtain. So let's spend some time to review patents. So why do we patent? We patent because patents can help safeguard our core technology, okay, to improve quality of life. You can say to improve oil production, but ultimately, when you drill it down, if we have better ways of improving oil production, we're also improving quality of life. All right? If you have faster way, more sustainable way of doing the job, the end user is going to benefit. So patents can provide opportunities for cross-license. What cross-license? Cross-license gives one party a license to use patented or copyright material in return of for a similar license. For example, so like Apple and Samsung, or let's say Total and Aramco can agree to cross-license their intellectual property. Patents can bring about that right. So Apple has a lot of patents, Samsung has a lot of patents, but Apple needs some feature of Samsung patent. And then Samsung can give Apple this patent to use, and Apple can give Samsung. They can do that because they have significant amount of patents in their portfolio. All right. Then another thing is that patents can bring about commercialization opportunities for economic benefits. All right. And profit. So the ability to exclude others for a limited term in exchange for public disclosure of how to make and use the invention. That is what is key with patents. So both the inventor and the society benefit from this exchange. Okay. And further, an invention can prevent others from patenting the same idea. And another important part is prestige as an innovation leader, that comes with the patent. So you get known within the industry, within your area of expertise. Okay, patents do not give the right to practice one's invention. It just gives you the right to stop others from practicing your patented technology, but it doesn't confer on you the right for you to practice your technology. And it's important that you understand that. And let me explain, for example, if I have a patent on a car, and the car has, let's say, wheels, engines, and body, just a simple car, all right? But somebody has a patent on the wheels. Another person has a patent on the engine. And then somebody else patented the body. So no one had put all these parts together to create the car. But I put this together to create the car, so I had a patent. So because the combination was new, I was able to get a patent on the car. But I cannot make the car without obtaining permission from the patent owner for the body, all right, the patent owner for the engine, and the tire patent owner. And similarly, none of them can make the car either because of my car patent that excludes them. So I hope that is clear. We can talk more about that later, but let's just talk about the requirements for obtaining a patent. So number one, it must be an invention. That means it must be new. The invention must be patentable subject matter, not known or obvious. So if I were to say it was known to use a nail, and I had the exact same thing, but put a screw as opposed to a nail, well, that's an obvious subject matter. Nails and screws are considered interchangeable. So anyone skilled in the art will know to replace a nail with a screw, and therefore it is obvious and you will not be entitled to a patent. So, you know, when you're thinking about doing a patent, it has to be original, it has to be new, and it doesn't have to be obvious. All right. So also it has to be a useful process, machine, or article of manufacture. And this usefulness requirement is very easy to overcome, and it's a very low bar because almost anything is useful. Another important thing is that you cannot patent the laws of nature, natural phenomena, or abstract ideas. There's always a debate as to what are the laws of nature. Okay. But Newton's laws of gravity, for example, you cannot patent this. Newton couldn't patent this either. Patents are valid for within a particular territory. So the US Patent Office grants a patent in the US to prevent anyone from using it in the US. But if I take that patent to knowledge and go to Mexico and make it and sell it in Mexico, and the US patent would not stop me. So, and if I go to Canada and do the same, and the US patent would not stop me either. So, however, I can't make it in Canada and then sell it in the US, because remember, I said that the patent right grants you the right not to make use or sell. So I can stop someone from trying to sell it in the US. They can sell it in Canada all day long. All right. So another requirement is who files first. So there is a first to file requirement in patents. So if you file the idea before I do, but this requirement is tricky because it's not just the first to file. Who is filing? The first to file has to be an inventor. So that means if I see something that you have created and I rush off to try to file it before you do, that patent is invalid, because although I filed it to prevent you from filing it, but I did not invent it. So I am not entitled to the patent. So the way I look at it is, if you solve a problem in a unique way, you may be entitled to a patent. I say may because you do not know what the prior art is, and somebody else may have solved that problem. So it may be unique to you, but it may not be unique to the patented world. So who is an inventor? This is a legal determination, and it is done on a claim-by-claim basis. So that means that until I actually draft the claims, I don't know whether someone is an inventor or not. And much of what is put in the body of the patent is background and prior art. So just because it's in the patent document doesn't necessarily mean that somebody contributed to the background. That somebody who contributed to the background is actually an inventor. But however, if it's in the claims, okay, it's bound to be novel or new. And then you have the possibility of being an inventor. And it needs to be, you know, that spark, that conception of the idea. It doesn't have to be used to practice, but it needs to be in the claim. So if you have friends, supervisors, colleagues, collaborators, they are not necessarily inventors unless they contributed to that conception. Okay? And the reason why this is so important is because if you get the inventorship wrong, the patent is invalid. So the big question is, how do you prove it? Okay. If I have a supervisor on, if I have my supervisor on it, so who's going to know and who's going to prove it wrong? But well, all I say is wait until the company lays off or fires any inventor on the list. Then we'll all know who the real inventors are. And that happens quite often. So, so if you name someone, just because you want to gift the patent to your supervisor to someone is a violation of patent policies, even in my company, and also it is being found out at the U.S. Patent Office, and that act can invalidate the patent. So I'm going to talk about the types of patents. Essentially, two types. The first one is the provisional application. So these are very special types of patents. So these provisional applications allow people, because of the cost of patents, because there's a filing fee, there's a fee when your claims are allowed, there are fees at different milestones. So because of all those costs, but you want to get something on file early, all right? So you can do a provisional application. So that provisional application is really, what it is just it's an evidence of making the invention. It establishes the filing date. It allows the term patent pending, okay, but it's not examined on merits. So what it does is that it has the inventor's names, it describes the invention, there could even be some drawings, and then you pay the fee. It does not need formal patent claims, declaration or oath at this stage, but it still needs an assignment. So you have to, for example, in Aramco, we assign these patents to the company because, in fairness, you use the company time, you use the company resources to develop the patent. However, it doesn't mean that it's not commercially rewarding for the inventor. I will explain that. So the provisional application will never become a patent, so you get that clear. But so that provisional application has to be converted within 12 months to a non-provisional application. And then you pay the additional fee for that. And then the non-provisional application is examined on merits before it can become a potential patent. So the non-provisional application has to include a specification which explains what it is that is invented. And of course, the claims. Okay? The claims are the most important items on the patent. Drawings only if they help to explain the specification, what you think is patentable. Then there are the formal requirements, including the oath or the declaration, where you are essentially saying as an inventor that we have read it, we have understood it, and this is indeed our invention. And then finally, you pay the fees to the patent office. So the reasons to file a provisional application versus a non-provisional application. So like I said, particularly if you are continuing to develop the application, you can file a provisional application to protect your invention. So, but if you know you are going to continue to develop it, to improve it, you may want to wait on a non-provisional application so you can include improvements in the final application that you file. Right. However, what that means is that though you only get protection for the provisional application, you only get protection by the provisional application on what you disclose, and the conversion to the conversion to the non-provisional application is where you get protection for all of the new developments that you added. Another reason to file a provisional application is if there are lots of people working in the area, okay, and everyone is racing to the patent office to try to file something. All right. So it happened to me sometime. I was discussing an idea, and then I discussed it openly, freely, and it sounded really nice. And I did nothing about it. I was, I went to the field. I was busy. And then just when I thought about putting it to paper and filing it, I saw that, my guy next door, some of my friends next door had already filed the idea. So I learned my lesson, So you learn your lesson this way. So if you're filing it, It just helps you to protect what you've invented to that point. So you can file, if you think of an idea, you conceive of an idea, you can protect that conception, that idea quickly with the provisional application. And also if there's imminent public disclosure, in other words, if someone is going to present it or do a publication on it, that means it's going to be made public. You can then also file a provisional application. In most countries of the world, as soon as that idea is made public, you cannot then, after the fact, get a patent on it. So what you can do is to file a provisional application quickly, so that you can have that public disclosure, and based on the provisional application, you can still file your patent. So I like to emphasize the requirement of the 12 months. Okay, it goes by very quickly because you have 12 months to convert it. And many times people may say we're still working on it, we'll file the provisional application. So yes, you may still be working on it, having filed the provisional application, but before you know, it's time to convert it without having done additional work. So you have to keep it in mind that at the end of the 12 months, you must file all applications, not just the conversion. And if you want to file it internationally, there's what we call the PCT, the Patent Cooperation Treaty. So you can file it within 12 months, and you have that 12 months to do all the improvement work, and the conversion of the US and to file the international application. And then the application will still publish within 18 months of filing. It will publish, and the time to provisional application will count as your first filing. All right, so I'll show you some sections of patents, and these are when you take a typical patent, you have all these sections. Okay, the abstract. The abstract is a short section of a utility patent that concisely summarizes the invention. Concisely, every word in the abstract is really selected, so you have to make sure it's concise. You don't have the luxury of using too many words. So the abstract usually commences on a separate sheet of paper under the heading abstract. Then you have the background section. The background section begins with a general statement about the field of the invention, followed by a slightly more specific statement of the field of the invention. Right? It discloses the general field of the invention, not the disclosure of how the invention really works. Then you have the summary of the invention, which is a brief, right, and general statement of the invention. So this section can identify the disadvantages of the invention, or the advantages, okay, or the disadvantage of prior solutions, and then the advantage of your invention, and how your invention solves the problems described in the background section. And then you have the description of the drawings of the inventions. You have to name every drawing. You have to number the drawing, and you have to make sure that the numbers correspond to the numbers in the drawing correspond to the numbers in the specification. Okay, so it's a lot of work. That's why attorneys have to eyeball this work before it goes to the public. It's a lot of work. All right, so you can have up to 500 names on. You can have up to 500 names in the drawings that you have to refer to. So the detailed information about the invention, the parts, what the drawings say, then the claims, which defines the meat and the boundaries of the patent. So this is the protection that you will get, just the claims. So the claims put emphasis on the claims, right? Because the claims is your protection. If somebody was to take your patent, wanted to do something different, he just needs to look at your claims and then try to solve the problem in a different way, different from your claims, and he will not be liable, right? So, so in drafting your claims, you have to make sure you're encompassing, and you make sure that it totally covers your work, for us, we have the luxury of, we have the help, we have the assistance. For example, my last patent, I just had the idea. I knew what I wanted. I knew what I wanted. I was solving a problem that the company was having, and I had a unique solution. I think it was a lot of our ESPs, they trip, and they are offshore. And number one, offshore, we have weather issues. So we only probably have good weather 30% of the time, 30% of the year. Then on top of that, we have limited boats and barges to service all our fields. And so when one ESP, when one pump fails, we have to look for a boat. We have to pray that the weather is good to go, and then we have to get a walkover rig and all that. So I found a creative way of knowing the optimum intake pressure for the ESP to keep the ESP running. So as simple as that sounds, there was a lot of work that went into it, depending on whether the well is a dual lateral or trilateral, like it's a smart well. All right, so quite some work involved, but by the time I solved that problem, then the outside counsel came with 24 claims. So I said, well, I had one idea, but then the claims became up to 24. So keep an eye on the claims. So in other words, the claims, so everything in the claims must have what we call antecedent basis in the specification, which mandates that claims particularly point out distinctly the subject matter which the inventor or the joint inventor regards as the invention. In other words, your claims must have support and be described and explained in the specifications. And the nice thing about the patent is that I can say car, car in the specification, all right? And then I will define it and as I want, and I use it in the claim. And for my patent, that car will mean what I define it as. It will not be the colloquial meaning of the car or by whatever whatever you think car is, but what I define it as. So that's a nice thing. But so claim has to have that kind of support. All right. So these are examples of one of my patents, which I did, and then so you see, so the patenting process here in Aramco starts from idea generation, and then so the prior art search is performed by the inventor. And why is this step? Why do we do this step, the prior art? Because you say it's an invention. So how do you know it's an invention? Unless you have some idea of what others have invented. You cannot say that your invention is an invention. So you might live in a bubble. You might live in a bubble in your company or your school without really knowing what the rest of the world is doing. So a quick search allows you to confirm if it's truly an invention. So don't send your patent to the lawyers and then they will do a patentability search and kill it. So patentability search is that search to see whether what you are calling an invention already exists as a prior act. All right. And so the next time you complete after you've done the patentability search, you complete what they call it an invention disclosure form. You get it approved by your supervisors, and then you submit it. Okay. And then there's a patent review committee that will look at it, review it, and then approve it, then send it to law for processing. All right. Okay, so that's the step I just described. It starts with the idea, and then they do a prior art search, and then they do the invention disclosure form, and we have it reviewed. And the patent review committee also looks at it, and if it's approved, then the law we'll start to process it. And law, it depends on your structure of your company. For my company, we have quite a number of lawyers, but the number of patents that the company is now turning out is really significant workload. So the lawyers use outside counsel, who specialize, who are patented lawyers, intellectual property lawyers. So they help to speed up the process. And so once they file it as a professional application, nothing happens. They just record the date. They have 12 months to convert. And so we typically tend to file more non-provisional applications than provisional applications here in Aramco, unless there's a strong justification for doing provisional application. We typically do more of non-provisional applications. So as for the non-provisional applications, we have to file the invention disclosure statement within 3 months. And that the invention disclosure statement is just one in which we have the obligation to tell the patent office all of the prior art that we know of. So anything that you believe is relevant to the invention, that patentability site that you did, and all the prior art that you are familiar with, you would need to tell the patent office. So you give it to the patent office, so they will use that. They will, of course, they will conduct their own search, but if it is found that you had prior art that you did not disclose, that would be inequitable conduct, and your patent could be invalid as a result. So when you are doing your search, make sure you are very honest to say what the prior art is, because they always have a way to find out if somebody else has the prior art. So their focus is to make sure that your invention is truly an invention before it is filed. And so from my experience, what hurts us the most is our own art, such as undisclosed publications that the company has made or prior publications of the company. And these usually come back to hurt us. And the patent office may say you're deemed to have known this. It's your own work. Because as the company gets bigger, it gets harder to track all the publications identical to our inventions that we disclose. But that has to be filed within 3 months. And once you confirm filing formalities, you wait for your first substantive examination. That could take up to 30 months. It's usually a long waiting period, and you can get your patent file anywhere from 20 months. 20 to 24 months, we're getting patent file within that time. But it's taking us like 98 days to file, and then 20 to 25 months, like I said, was to grant. Yeah, that's about the, sometimes it could be up to 3 to 4 years before you get patent grants. So you have to have a lot of patience. And once you file that provisional application, nothing happens if it's a provisional application. If it's a non-provisional application, it goes through that route, and it could take up to 30 months before it is even examined. Okay, so when the law receives it, they have what they call their first action, and it's reported to the inventors. I show you an example now on the screen of my first action. So the first time what they call the first action, they will typically reject all the claims. Okay, you can see that all the claims, like number 7, all the claims are rejected. So if they reject your claims, it's not a big deal. 95% of the time, they reject all claims. So you just need to work a little bit more. You have to convince them that it is, you tweak it, tweak the language and work on it, and resubmit it. And then after that, they will give you a notice of allowance and tell you that the fees are due, which is the one you see there. And once the fees are due, you go pay your fees, and within 6 to 8 weeks, the patent will be granted. And this is the last one of the last one I had granted. It was issued in April. And right, so that's one of my patents. All right, so this is the graph that is showing that Aramco's ascent in patents, that we're growing a lot. You can see that the number of, we're leading the industry actually, with Exxon being our closest rival. We filed by this year alone almost 700. This statistic was as at last month. So by now we have probably gone past 700 granted patents. And to have these granted patents, probably filed maybe twice or three times that number. And in 2021, we surpassed. Sorry, I think this was last year. This statistics was for last year, 2020. And in 2021, we have surpassed 300, and we're just in May. So the company, is really growing in this. And this are statistics in terms of portfolio. All right, so I'm going to show you one of the things we really do to encourage our teams, to be innovative, and I hope you'll find it interesting.
Here in Napan Well Services Hackathon, we are presenting really challenging criteria to all the people who are over here. The goal is to come up with patented solutions wherever they can be patented, and the end conclusion would be to find solutions for the industry, make our lives easier, produce more oil and gas as well.
We're going through the course here this afternoon. There's been a lot of thought-provoking exercises that have been kind of uncovered and developed. Innovation and critical thinking, and really pushes you to your boundaries of your experiences.
Now we have 3 teams looking into real challenges here in Saudi Aramco, and we hope to achieve our goals and objectives, which is aligned with the company goals and strategic planning. We want to ensure the reliability of our ESPs to deliver a sustainable product to our customers.
We're excited to have the teams working on their prototypes and have them pitch to their management and potentially turn these ideas into reality.
They come up with a very brilliant idea. We come out of the box kind of thing, because the way that the whole methodology it works is that it leads you to think outside the box.
Currently we are on the second day. We are working on preparing the presentation to the management. We stimulated the idea yesterday. We have to present it to them. We are excited to do so.
The room is very energetic. We're having such a good time. A lot of disruptive thinking, a lot of new ideas that are coming out of this hackathon, and we're really excited to see what the end result is going to be.
Every Napan Well Services Department employees has a creative potential. And from the moment they express their potentials, they are starting changing the world.
Okay, so that's what we do here, and what I do on my personal level as SP district lecturer is I've been very burdened by training Nigerians. And I had an initiative which I set up to really help add value to our schooling system and also teach people patenting ideas, groom the younger generation. And this is just a quick if you want to join, this is the link. You go there and you see how to join. But we're going to be very active in supporting students and faculty members and releasing creative potential. In a nutshell, that is my presentation, and I can take your questions, and I hope I can answer them. So I yield the floor back to the chair, Mr. Debola Dada, so you can take it up maybe.
Thank you very much.
Yeah, I think the moderator.
Thank you very much, Dr. James. That's a great presentation on intellectual property and how to acquire intellectual property right. So I just want to ask from the audience, participant of this workshop, if you have a question, can you quickly put your question? You may decide to send it as a chat, or if you want to, maybe you want to say it, you can just raise up your hand so that we can see that you want to ask a question. So that you can unmute your speaker and ask your question. Any question from participants of the workshop? Question? All right, I just have some few questions while we're waiting for the participant to participate in raising some questions to deepen our understanding in patenting and intellectual property right. And the first question I want to ask is that for clarity, what is the duration of a patent? If a patent is issued, what is the duration before it will lose its validity? James?
Yeah, so you have typically 20 years from when.
Pardon?
20 years. So you have a 20 years validity for patents.
Okay.
So you have 20 years validity. Within that 20 years, you can keep people, you can deter people, you can stop people from using your patented ideas.
Okay.
And if you're smart enough and your company takes it up, you can, within that 20 years, go to commercialization, or you can license that patent to a third party. And there are examples of that, a lot of those examples where we license the patent to a third party, or you can have a spin-off company out of the patent, and the company might elect you to be the representative in the board of that new company because you know more about this patent. So it depends on the value of the patent, it depends on the application and the scope of the patent.
All right.
You have 20 years protection. After that 20 years, a lot of people you see, like in the pharmaceuticals, Pfizer drug patents an idea.
Yeah.
And a lot of other companies are waiting in the wings.
Yeah.
And after that 20 years, they come and make generic drugs, which is a fraction of the cost. The reason why it's expensive the first time is because Pfizer is trying to recover the cost of their patent and all their manufacture. But after 20 years, somebody can go to China and bring those generic versions at a fraction of the cost, and the person will not be liable.
Okay. Secondly, before we take that, we have a lot of questions here that I will quickly read out for you. But before we go on that, the patent itself, the license itself, I hope the license needs to be maintained to maintain its validity till the 20 years elapsed. Would that be some form of subscription to maintain the validity of the license, the patent license?
Well, so that period of 20 years, yeah, so you have to, so for us, we don't have, like, we are protected by the company. Whatever the company does legally to renew the patent, they go on our behalf. Any fee that has to be paid, they go on our behalf. We don't have any problem with that.
Okay.
The company doesn't even tell us what, but they do a lot. They do a lot to make sure that they are compliant with the US Patent Office requirements.
That's all right. Thank you, James. I have a few questions for you here. Number one, the question that was asked by one of us said, can one patent an equation about cost reduction? Number two, what is the cost to obtain a US patent? Did you get me, sir?
Equations
to reduce about cost reduction, yeah. That is the person propagate equation to reduce cost of operation. Can you
equations are hard, laws of nature, they are hard to pretend, but yeah, maybe you can have it as a trade secret or something, and you can have some legal protection. But yeah, so you can do that. It costs, well, so the cost really of patenting an idea varies. So if you have to use an outside counsel, they have their fee. So outside counsel, like counsel that take your work and go on your behalf to patent office, they have their fees. Then the US Patent Office itself has its own fees. The kind of fees I see, they're typically less than $2,000.
Yeah.
So they're typically less than $2,000 at a time. But so you have the filing fee. You also have a fee when a claim is to be allowed, when you have what they call allowance of claims.
Yeah.
Because the first time they reject all the claims, they're telling you go and tweak it, because this claim is identical to somebody else's work.
Yeah.
Go to claim, did work on it, so they allow those claims. When the claims are allowed, they will now tell you that this fee is due. So another fee is due for the claims to be allowed. But after that claims are allowed and the fees are paid, usually takes between 6 to 8 weeks from that period, and then the patent will grant. And when the patent grant, that's the big deal, because when the patent grants, you can recoup all these monies, because then you can have, sometimes you can have a lot of third parties calling on you saying they are interested. A friend of mine fell into that situation where the company was interested, and then our company can decide whether they want to sell that, whether they want to license another company, or they want to own it, they want to spin off a company out of it.
All right.
To
Thank you for that question. The second question I have for you is that what exactly is the relationship of the following? What exactly is the relationship of the following? Patent, trademark, and copyright. What is that relationship?
Patent, trademark, and copyright. So I think I dwelt a little bit on that. Patent is the the hardest to obtain, is the most difficult. Sometimes, and then is often the most valuable, okay, in terms of economic value. So that's patent. Trade secrets may be some formula that gives you economic value, and so your success with it depends on how well you are able to keep that secret. You know, for example, the Coca-Cola formula, I don't even know where it was kept. I spent a lot of time to try to ask, see where did they keep the formula for the Coca-Cola? They've had it many, many years. All right, but 85% of the value of Coca-Cola lie in that trade secret. You know, so how successful they are able to keep it, and so that's copyright. Like copyright, if anything is in tangible medium, I can sing a song; it's not copyrighted. But if I put that song into writing, or if I do an artwork, you know, and then you take that artwork, once it's in a tangible medium, it has legal protection, whether or not I file for legal protection. So that's copyrighted. The trademark, again, I think we talked about the trademark. The trademark is something let me see if I can go back. Yeah, the trademark, this is the trademark. So the trademark, I'm not sharing screen. Let me see if I can share my screen and help you there. Okay, so that's it. So what I said about trademark is it protects your words, your symbols, your sounds, your colors, you know. I think NTA has a trademark. What's the trademark of NTA? The sound. I don't know, NTA, National Television Authority. I think there are so many of them now.
The sound and the color of their painting on the NTA.
Yes, this is the trademark. Many of those other television houses are using. BBC has its own trademark. This is the BBC NBC channels. MGN. I don't know if you know MGN, the movie. The guys who do all these films. The Lion, MGN Lion.
Yeah.
Those are trademarks, and you can have your own trademark. And
sure.
I have mine, and I play. So these are trademarks. All right. So once it's something that is valuable to you, and you can use it to distinguish yourself. Once anybody sees it, they know they can associate that brand with you. They can trace it to you. That's a trademark.
Yeah.
And so sometimes patents are preferable to trade secrets. For example, if you can choose protection of trade secrets over patents.
Yeah.
Because it's not risk-free. So, but while the patent will only remain in effect for 20 years or less, the protection it provides is considerably stronger. So trade secret protection only applies to unlawful breaches. All right, and sometimes, but it's easier to lose patent rights than trade secrets, because trade secrets derive their legal protection from the inherently secret nature. So if you lose how to keep those secrets, let's say somebody in the votes leaks it out, then you may lose your trade secret. And the patents, by contrast, can only be protected through public disclosure. So once you disclose patent, you have protected your patent, and you have legal protection over that patent for 20 years.
Okay.
It's only when an inventor refrains from describing prior art or other important details that the patent can become invalid.
All right, thank you very much. The next question we have So somebody was asking which office in Nigeria is responsible for patent. Okay, I'll just give that answer straight away so that we can, James can entertain other question. Is Trade and Commerce, the Office of the Registry of Patent Registry. So if you go there, you get your work being processed filing for patent in that. And if you don't want to spend money to filing for patent, you can also pass it through NOTAB. NOTAB also responsible for that. NOTAB is National Office for Technology and Acquisition and Promotion. National Office for Technology Acquisition and Promotion, NOTAB. NOTAB can also file in your patent for you at no cost. But if you want to do it personally, you have to go to Trade and Commerce and go to Patent Registry and file in yourself. This next question we want to look at is one of the participants also asked a question. If you get an innovation to an existing idea, an improvement on an existing idea, an existing thing or idea or structure, can you claim a patent? That is innovation. So patents are also driven in innovation. James?
Well, so if you can improve something, you have to...
An existing idea, existing structure, existing idea, existing thing, if you made an improvement on it, can it be patent?
Yeah, so it depends on if you have a unique conception over that already existing idea, and you can prove that you added something substantive, then you could potentially patent if it's a remarkable improvement. But it's not just, it won't be a cosmetic improvement like bigger wheels for the car or just something cosmetic. It has to be fundamentally value-adding improvement, and therefore you can make sure you work with a lawyer to examine the claims regarding that invention for them to determine, to examine it of merit and make that determination whether or not to. And you have to ensure that you have a comprehensive prior act study to see whether somebody else has not made that improvement. So these are some of the things.
That somebody has not made that innovation before. That will actually lead to patentability search. If you want to claim your innovation that is an added value to the existing knowledge or thereabout. Is that correct?
And the patent office requires you to do a comprehensive. They require you to do a comprehensive patentability search. They will do their own search. But then they give you the opportunity to do your search. But if they discover even a publication, a prior publication, if you have published a paper about that thing and you've made it public knowledge, that sometimes will invalidate your.
Yeah, that brings me to the next question. That this should be a comment, James. It simply means that if you have the urge, for those that in academics, if you have the urge to publish your work, I think it would be better you go for provisional application of that product first before going for publication of that article, so that it can still be patented. Is that correct?
Yeah.
Okay.
That's true. So that's the way you protect your work. Okay. Once it is public, it becomes public knowledge. Then you cannot, after the fact, claim.
Right. The next question I have is the question says: is there possibility of collaborating with firms, industry to progress a patent? Do you have an instance to support your answer?
Yeah, so if you're working with outside parties, you can do that. But what I encourage you to do is to sign a non-disclosure agreement with a confidentiality clause. Working at Aramco, we have so many things to guard. We can be working with a contractor, and then the contractor goes off and files a patent. that, and then prevent other contractors that we may want to use subsequently, which could put us in a very tough corner. So, but we have the liberty, the latitude to work with outside parties. But what we do is we encourage a non-disclosure agreement to be signed. That non-disclosure agreement will have a confidentiality clause, and upon executing that agreement, we'll give it to the lawyers to look at. Our legal team will look at it. And then many patents have been entered into by third parties between the company officials and other outside parties, third parties, vendors. I've done many of those kind of.
Yeah, that's correct. And also, in addition to what you are saying, the knowledge you want to patent must also be profitable to the organization.
Yeah, if it is profitable to the organization really delights in the value creation. Yeah,
it must have value. Yeah.
Competitive advantage, especially sustainability. How to make life better for everyone. So those patents add value to the company, and the company really takes interest in developing those patents. And they have a pipeline to screen all the patents and see which ones can go to market sooner.
Yeah.
And then they have a portfolio of ranking, and then they're going to add value, short-term, quick wins. They process it and accelerate its development up to commercialization, and it becomes value-adding.
Okay, the next question I want to ask, thank you very much, James. The question asks that, how will you know that your patent is being used without your permission, especially when the probably is not in a mass production, it doesn't involve mass production. How will you have a knowledge about that somebody is using your work somewhere without your knowledge? I think that's quite a tricky circumstance.
It is hard to tell, but the U.S. Patent Office is very, very serious with patent infringement, and the rate of breach can be written once it is found that someone is. It depends on the jurisdiction. If it is some areas have a lot of CDs dedicated by some communities. I have seen that a lot, and they hawk these CDs while you are in the traffic hold-ups, and then you meet the artist. I think one of my neighbors in Lagos works in this movie industry.
Yeah.
Last movie, very well known actor. And he went out sometime, and he saw his being hawked by some traders. And he really got mad and offended. And because those artists, it cost them a lot of money to put all those things to do movie production. And they need some protection so they can recover their money, pay all their creditors, and then make some profit. But once people begin to mass produce their CDs, then they don't derive economic benefit from it. And so that's where his anger was coming from, and threw the whole thing into the garbage and got into a fist fight. Almost got into a fist fight with the hawkers. So it depends on the jurisdiction. If he can pursue legal remedy easily, or he thinks that the cost of pursuing legal remedy is worse than him just walking away. So it all depends on what protection he gets and what jurisdiction he's in. If it's in a place where they take those things seriously, then he can make substantial, can get a good.
And also the visibility of the product. If the product is not visible, used by any other person, and it's an individual that is using that your knowledge, is not trading with it, is not making profit with it, it will also be difficult to know that somebody is using your product generally.
Having said that, there's international protection for intellectual property.
Yeah.
And you can resort to prosecuting people internationally, and you have the full backing of the U.S. Patent Office and all the, to prosecute anyone who is in infringement of your intellectual property rights.
Okay, I think
you have the muzzle.
Yeah.
You have the muzzle. If you have the muzzle of your company behind you, they can throw their weight behind you.
Yeah.
That prosecution. It makes a substantial.
All right. Okay, I think that brings us to the next question. When you talked about international protection, how can you make your patent to be accepted internationally? What is the process to take your product to an international patent license, and so that all over the world you'll be respected for your product without being tampered with it?
We file typically in U.S. Patent Office, but there's also the Patent Cooperation Treaty, PCT. If you want to file internationally, so they will check the Euro Patent Office. They will file it in the Euro Patent, so that automatically gets your patent in the Euro Patent Office, U.S. Patent Office. Then in other important patent markets are China, Korea, and I think Japan. But most of the important patents make their way to the U.S. Patent Office. So even all these Korea, Japan, China, the very top patents also try to get protection from the U.S. Patent Office.
Right.
So between the U.S. Patent Office and the Patent Cooperation Treaty, can wide international protection for your intellectual work.
All right. Okay. What about the World Patent Organization? The WAPO. World Intellectual Property Organization, WAPO. World International World Intellectual Property Organization. World Intellectual Property Organization, WAPO.
I need to check if that is a regulatory body or whether they are actual as well. Yeah, but it's not one that's I'm sure. I need to double check with our legal team.
Okay, because there's two platforms. We have the World Intellectual Property Organization. We also have the Patent Information Service for Developing Countries. So we have the WIPIS and WIPO, and there are also platforms for internationally patent right licensing. So maybe may also look at participants may also look at it and also take an advantage. But on before you get to WIPO, you must have done your patent at your country of host. Then from country of host, you can transit to WIPO, to the World Intellectual Property Organization for licensing. Yeah, somebody just sent in the last question. I think this will be the last question, so that beer is already 7 in Nigeria. Is there any difference in the following as it relates to patent, seal, transfer, or license?
Can you repeat that? Those terms?
Is there any difference in the following as it relates to patent, sales, seal, transfer, or license? Seal, transfer, or license?
Okay, those are legal terminologies. A seal is, well, from what I understand it to be, is like the engineer's seal. So yeah, it's just a device that you use to join two things together. So as to prevent them. You know, so legally speaking, it could be a piece of wax, like and then other material, and you stamp it. And the guarantee of authenticity. So, for example, we engineers, we have seal. I belong to Nigerian Society of Engineers. I'm also Korean, but I'm also Canadian registered engineer. And we have a seal that whenever I do a document and I want to show that it's authentic, I can attach my seal to it. I say, I've read this document.
Yeah, James, sorry. Just a little correction in that question we just got now. Is the question is not talking about seal, it's talking about sell. To sell, I think it's making what the question is actually saying, to sell your patent, to transfer, or to license it out, to do something.
Oh, so sale of patent. Yeah, you can. There's a law that governs the patent law that governs sale. So you have to value your patent and make sure that once you are convinced that the offer is a good consideration for the intellectual work that you have put, then you can make that determination and then decide maybe you want to accept a sale or not. You can also transfer the patent. So how we do this here is we look at our core business.
Yeah.
Okay? There's some patents that really go into the root of our core business to add value. We pursue those. Those are the ones to go into the pipeline first to make it into the pipeline. There's some like sustainability patent. If the patent comes, how to sequester carbon, how to remove harmful gases, how to make life better for people, humanity. Those ones, the company puts lots of interest now into those ones. All right, so they make it into the pipeline. How to get oil? Lower cost per food conditions for drilling people, or lower production cost per barrel for the production people. Those kind of patents make it into the pipeline first. So we're not likely to sell. We're not likely to sell those ones because those create value for the company. We can transfer patents. For example, if, like I said, if Apple wants a feature in when you got Android, those two of them, they are in the business. Samsung and Apple. Apple wants something in Samsung. Samsung has the patent. Apple doesn't have it. And then Samsung wants some feature in Apple, but Apple has the patent for that feature that Samsung wants. So they can cross-license, they can transfer their patents based on agreements. Because the alternative is to pursue litigation, which doesn't go anywhere sometimes. They go to court, they fight, they make claims. Because, so they can just agree to cross-license, transfer their patents, and they do it a lot, all right? They do it a lot because, like I said, most of them have a substantial portfolio of patents, and that's why they can do that. If one was broke or one didn't have anything, then it has nothing to transfer, you see, and then they can't even have that conversation. They can't have that. So that is how sale and transfer. But another one will be for sometimes the company can sell the license to that patent to a third party. All right, maybe it's not our core business. Maybe it's not our core business, or maybe Halliburton and Schlumberger, they are better set up to do this kind of things. we can sell the license to them. Or even Schlumberger can even also sell their license to certain of their patent rights to us if we desire to go in that area. So these are some of the things about it. And there are lawyers who earn a living with all these issues. But yeah, so.
Yeah, thank you very much. I think we're going to end the question and comment section now. I want to thank you sincerely for making that time, busy schedule and time zone difference. We are pleased to have you on board. As we normally say, we hope that we'll be calling you from time to time to share your experiences with us, which because already in this workshop, we have students, we have those working in the industries, we have lecturers who are also training students for the oil and gas industry. And so it's a great pleasure having you. We are proud that we are having one of ours in Saudi making waves in terms of intellectual property strength. And we wanted to thank you very much.
Yeah, thanks, Briggs. I really enjoyed your perspective on this section. And I think that Ebola has the gift of selecting all the right guys. He just looks around like he doesn't know what he's doing, but then he picks on all the good guys for his Port Harcourt section activities. I'm so jealous seeing one beautiful program after the other from the SP Port Harcourt section. So keep it going.
All right, thank you very much. Joseph, are you there? Joe? Can you flash the agenda to see the next thing online, Joe? All right, Joe. Yeah, Joe, can we get the agenda to know what is on the line next?
Somebody said that you are muting. Okay, let me see if I can unmute Dr. Briggs. Dr. Briggs, unmute.
Technical issues.
I think Dr. Briggs wanted to be unmuted.
Yeah, I think.
Yes.
All right.
Yeah.
Okay, all right. Can you hear me?
Yeah, Joe, you are right.
Yeah. Sorry. I had a network glitch.
Yeah.
So, Simeon, can we go to the next on the agenda?
Let's,
Thank you very much, James, and thank you very much, Dr. Briggs. We are very grateful.
Hello, please, let's take a picture now, please.
Okay.
Okay.
Yes, please. So thank you so much. While we're taking our pictures, we can also smile. Thank you so much, Dr. James, as usual, delivering. We really appreciate you always giving us something good in Section 103 Port Harcourt. And thanks so much. As Dr. James always say, you know, we always find a way to look for a suited moderator. So I think you recognize that. So, but it's our trade secret. So we'll keep that with us. So thank you so much, Dr. Briggs. Also, really appreciate this. We wish you the very best, both the presenter and also the moderator. We appreciate it, but we can always call you anytime, please. Oblige us. Thank you. Simeon, are we done with the pictures?
Yeah, some persons are still putting on their camera, so
okay. Please help us to see your faces. It's very good for our magazines, you know. Okay. So thank you very much. So I think we can, what's the next thing on the agenda, please? Dr. Joe, you can go ahead.
All right, Simeon, can you quickly display the agenda?
hello, the agenda is on the screen.
Okay, so we've had the wrap up, we've had the question and answers, we've had the photograph. Can we have the question of the day winners? Do we have the publicity team here? So you can just display it if they're not here. Display the winners. Normally every month we send out some questions. We call it the Know Your Industry. This is for May. And then rightly, you can see the variance of the questions we normally have, from technical, sometimes to current affairs. You know, we try to mix it a lot. Sometimes even to what has happened in the last MTM. So it's not so. We always have 2 or 3 winners, and we issue them certificates. So congratulations to Eric Chuku Chioma. It's a student. Normally, I would have wanted her to put this the affiliation, the chapter. And then we have Antigua Fiong Eyo, who is should be a YP working with Temple Group Limited. Congratulations to you both. We'll communicate your certificates to you via email. Thank you so much for your participation. Next, please. Simeon, next, please. Okay. So the next thing we have is just the membership, and then after membership, we do an announcement. So go over to membership quickly. Normally, if we have the membership link, you can just put it on the chat box. This is obviously for non-members. If you want to be part of doing, normally for this kind of a presentation section, it is only for our members, but you know, sometimes we try to allow non-members, but if you want to continue having this kind of joyful, nice technical stuff with us, I think it's just easy for you to join us. So normally they should be putting a link by membership team. We know what SP is all about. to collect, disseminate, and exchange technical knowledge. We are into corporate social responsibility. We are into community engagement besides the technical work we do. So we try also to impact positively in whatever community that we are. So Section 103 operates normally in the southeast parts of Nigeria. We have at least 12 universities, including one in Cameroon that is under us. So we have a lot of things to cover most of the time. But we have a lot of volunteers also especially from our young professionals. So we have several meetings, we have training programs and study group discussions that covers many of the technical sessions, from reservoir to HSC to production to gas to even management. So Simeon tried to put the link for the membership. It's clickable to put on the next slide. And I think honestly, fee is the cheapest. It belongs to about 5 international organizations. And sincerely, what I gain in SP is far more than what I gain in others. And still, to be sincere, it's very cheap. To be sincere, if you belong to other professional organizations that are international. So, and besides it, with the COVID-related stuff, SP is still doing a waiver, depending on your circumstances. So you can let us know, and you may grant a waiver depending on the circumstance we're in. Next slide. Next slide. Next slide. So now we'll just go straight to announcements. I think we're on time. We're 7:30, so we still have 15 minutes to. So immediately after the announcement, close the remarks. If you still want to interact with the moderator and also the presenter, I guess the best way to catch Dr. James Arakwe LinkedIn. He's very versatile on LinkedIn. Ask him all the questions regarding all these technicalities from him. I hope you have some ties for you on LinkedIn. So these are members 2020-2021. We are 17 members strong. So each year, and this is what we have. So thanks to all these different of communities to deliver programs for us. All appreciating the next slide. Next slide, Sonia. Events. The first thing tomorrow. Okay, it's one of I don't know if you can still believe some comments on with our portable water. It's unbelievable. So, SP, not just only technical, but we also want to support as much as we can. And we try to funding among our members and all these issues. Next slide. Okay, so tomorrow we're having a webinar by 12 p.m. We are collaborating with Study Globally. They will be presenting what we call the state of purpose. So if you have studied abroad, they are going for the graduate courses. Definitely, in most cases, they will ask you to write a statement. So this is what we used to judge our students, our YPs in the last scholarship program. And we can see clearly from there that we still have some students and YP that needs to improve how to write a statement of course. It's key about yourself in a very convincing way and for people to accept you. So it will be 12 tomorrow. It's on our social media pages. Click to register, and then all the dynamics, all the trade secrets. Let me use the professional word. All the trade secrets of writing a statement of purpose. So you're going to get that on 12, which I should be public holiday. now. I don't know this year, but I think it should be a public holiday. We're having our annual share. So each year we do this just to sort a this year we are spotting every signs of autism disorder. So we should know about autism. Many of the children, some are not even recognized early. I mean, earlier you recognize them better. Okay. They always make life from many of the examples we have seen, but issue environment. So we'll be having a crowdfunding on 1,000. 1,000 doesn't cover anything. We're going to give you a lot of shares and so on. But so you are invited to Python International in if you make a full donation, you are invited to do that. Social media link, and then you register, or you can just do a free will donation. That will be happening on the next slide, please. Okay, so I think here once in June 5, we're having digitalization webinar. Our study groups will and then discuss about digitalization and changes having in their work area. We are bringing us a professional that's going to teach us how to digitalize our various works using low-code means like Power BI and so forth. It's going to be a very good and very nice engagement. We're also in our next monthly technical meeting on June. This will be fantastic. Of course, about the governance, which is one. We're having our management study group also sometimes in June. Another presentation in June 29. Okay, that is the management study group. And then for our July 8th, we'll be having the monthly technical meeting also in July. This is also be a very fantastic one, basically about energy efficiency and so on and so forth. Just for your information, if you don't know, Total, okay, I work for Total. As of today, Total has changed from Total to Total Energies. So most of the things we do in the industry now, you'll see that it's correlating towards energy. We want to speak on renewables also. So just for your information, Total as of today has changed to Total Energies right from today. So that most of the industry, formerly oil and gas, moving in the space, even though schools so changing, a lot of things changing, and we have to move of what is happening so that we can match in 50 years to become relevant. Thank you so much for everyone. Just quickly take, I would like to appreciate Dr. James Arukwe and the moderator, Dr. Briggs. So really appreciate it. Thank you. We know you're an expert also in intellectual property yourself. We appreciate also our students, the practitioners, we appreciate young professionals. We have many of collections, not only in Nigeria and some parts of the world that have joined us. Thank you so much for joining. If you have good and very nice presentation or webinars like this, please always also let us know for us to collaborate more on this. I'd like to appreciate some of our directors. Alaji Othman, I've seen you. I've seen some of our directors have come in and gone, and some are still there. We appreciate you. We appreciate also our young professionals. In fact, young professionals always doing us to run most of the committees in sector. So the best way to catch us is our social media spaces. It's always vibrant, always interesting. From Facebook, Twitter, and to LinkedIn. And especially my favorite is LinkedIn, in fact. But not just in any one of these. Give us some comments and some ideas on how we can save the world. So knowledge sharing, especially as we are today, and also engaging with their various communities. So thank you much. I think that's all for me. And wish you the best. Please have a good night, and we'll see you soon. Thank you, everyone. Thank you.
Thank you. Good night.
So, good night, buddy. Thank you so much.
Thank you, everybody, and good night.
Thanks.
Thank you.